Hi, everyone. Harry here to talk about a decision by the Seventh Circuit Court of Appeals. In other words, the level of federal court just below the Supreme Court and above the district court. This one out of the dispute in Chicago about Trump's sending federalized National Guard, both purportedly from Illinois and Texas. He was challenged by the political leaders of Cook County and many others who said, hey, you're relying on a section, a grant of authority, 10 U.S.C. 12406, that, and now this is the same ruling and analysis from Judge Chuck Breyer a while back in San Francisco, which the Ninth Circuit sort of put on hold. And now again here, where basically, and again, Judge Immergut, and I made a pretty big deal of it at the time because I saw it and see it as the way out of this tricky puzzle that higher courts, and I expect the Supreme Court will very much be in this column, are inclined to emphasize the great degree of deference owed to the executive. And here the Seventh Circuit didn't contradict what the Ninth Circuit said in the Breyer case, and yet it came to a conclusion affirming the district court. So let me explain a little more what I mean. Breyer looked at the same statute, which says whenever one of three conditions exist, the president can use this authority. He took the whenever as meaning that it was his call whether those conditions exist. The only one that really could be out there would have been a rebellion. And he said, I see no rebellion here, and gave temporary relief. The Ninth Circuit above him by a 2-1 vote and a very cryptic opinion just simply said, the president has deference. You got to give great deference, and the district court didn't do that. We're reversing. But they didn't really try to apply or do anything of the like. That's why I thought it was really important and encouraging that Judge Immergut, who is in Portland, also in the Ninth Circuit, said, Ninth Circuit tells us, instructs us, we've got to give great deference. That's fine. I give great deference. But that's not the same thing as just swallowing whole a assertion by the executive branch that is, quote, her great quote, untethered to the facts. In other words, she pointed the way out of the possible trap of saying, even though we know this is bullshit and Trump's just doing it for political reasons and doesn't care about the truth, we're going to let him do it anyway out of a principle of deference. And her saying, no. Deference is one thing, and crediting a lie, not, she spoke more decorously in judicial language, is another. And that's pretty much what has happened now in Chicago. So you had the district court say, along the same lines of reasoning, there is no rebellion here. What there is are peaceful demonstrators, a couple incidents, but sporadic acts of violence are not the same as a rebellion, which is an attack on the authority of the United States government. And it is just completely fanciful and fiction to try to equate those two. All right. The administration then does its by now well-established, signature strategy of going up to the Court of Appeals and saying, emergency. They say to the Seventh Circuit, the court above Judge Perry on the district court, and say, you can't do this and we need more deference. Actually, they even say in the Seventh Circuit, it may not be reviewed at all. If the president says this statute gives him the power, that's the end of the ball game, even if it's total fiction. So the Seventh Circuit wasted little time in saying, no, that is not what that case, this very old case, means. And then even more importantly, they marched on and basically parroted the line of the Ninth Circuit, saying great deference. To be sure, we give great deference, but then just, we can't just adopt a lie. And that's basically what so much of this is going to come down to. It's the case. I say this with some element of disgust, but really just objectively, you have this administration, this president just lying all the time. And in this context about the question, is there in fact a rebellion, happening on the ground, as there must be for him to exercise this power? And that what the Seventh Circuit, the court just below the Supreme Court, has now said is, even giving deference, the answer is no. The district court found no. And by the way, we can't reverse that finding unless it's clearly erroneous. And it is not clearly erroneous. All the government came forward with were, a couple little ragtag skirmishes. That is just not the same as a rebellion. And by the way, agreeing with Judge Breyer, given that the statute as it's constructed puts rebellion and the question of whether the president or local authorities are completely outgunned and can't execute the laws, says that that's something that courts ultimately determine, even if the president is given deference, and what they basically say is on the facts. But even providing deference on the facts, what they've pointed to is just something that under no reasonable construction makes a rebellion and makes a few ragtag skirmishes. Therefore, we agree with the district court. We will not take off the relief that the district court gave, which, by the way, to remind you, it's a little bit odd. The district court said you can keep the National Guard in Illinois for now. They just can't do anything. They can't. So because you can't have this whole broader basically exercise of having all these federal agents from ICE and other places in to do their stuff. That's what the district court put on hold. So technically, she said, I don't have to kick out the National Guard, and she hasn't. That includes presumably the troops from Texas, which makes for a funky situation, troops in Texas in Illinois. But anyway, the basic holding is they got nothing to do because there is no rebellion that's happening. And the Seventh Circuit just below, even adopting and acknowledging this principle of great deference as the Ninth Circuit does, says, but that doesn't mean, and we won't allow it to be used to basically indulge a fiction. There's, maybe a little bit of some dust-ups. That is not a rebellion. You are out of here, administration. To my mind, that kind of reasoning is really important, because I think it's likely at the end of the day that the Supreme Court will insist on some level of deference to the executive. So being able to both take that aboard, as I think is inevitable, and still be able to call the administration's assertions and characterizations of things like rebellion as false and not give them a force of law is, really essential. The opposite being, of course, what the administration wanted. All the president has to do is say it, and he's off to the races, including, this is an aside, but an aside I look at very carefully all the time, including messing with elections by virtue of that same power. Oh, we have a rebellion. I say so. I want to post National Guard people at every polling spot, for example. So I think the stakes here are high for the elections, and certainly high for this. And the basic ruling from a pretty high up court, just below the Supreme Court, that we defer, but that doesn't mean that we call a few skirmishes a rebellion. That's not what they are. That, I think, is a really important kind of line in the sand. Only the Supreme Court now would be likely to reverse it. That doesn't mean it won't, But this, I think, is really an important benchmark in the overall pushback in favor of democracy, that a court just below the Supreme Court has rebuffed the administration in this way. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.